had to point and deploy a taser. And that another officer had to point their pistol at a defendant. An eyewitness saw the defendant shove the victim while near the police station. An RNO causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
I just don't think she's going to do what anybody asked her to do.
All right, guys, buckle in because we've got a couple of cases today that spiral into absolute chaos the second they hit the courtroom. We're talking entitled brats who think laws are more like polite suggestions, like speed limit signs on an empty highway. We've got contradicting stories that don't add up, defenses so weak they might as well be held together with duct tape, and a no-show defendant who treats court dates like optional RSVP parties. Oh, and just when you think it can't get any messier, here comes the domestic violence case, stacked with a side order of cops getting beat up. Some of these defense arguments are completely mind-boggling, like they're expecting the judge to suddenly forget what's written in the penal code, and yet the defendants keep doing the exact opposite of what the judge wants to hear, which is like trying to win a marathon while running backwards. So the real question is, how much rope does the system hand out before someone finally hangs themselves with it? Let's go ahead and dive in.
Asked bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed as a result of having the tether plates. No longer able to, in this case, he was no longer able to maintain that employment. He is hoping to be able to get new employment and is asking that the court consider a no go-to order, a no contact order, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program. Text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Chenal County. Otherwise, he's just asking for some order that would allow him to work and just not have that kind of contact.
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event for a series of events that occurred where the defendant assaulted the victim at not one but two locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let Ms. Barroso finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple of things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were.
In which
that it was,
charge?
I'll start with the domestic violence. That with those charges, that there was a more complicated situation. I believe the officer said the report says something to the effect of, and this would also go to the property, that there had been physical altercations between the two of them, fighting between the two of them, and breaking of objects between the two of them.
This defense story is so unhinged, it's almost impressive. They're really out here trying to put this guy back on the streets like he's some misunderstood choir boy. The bond already got cut from $50,000 to $5,000, which is basically a clearance sale in legal terms, and they're still asking for more. That's like buying a Ferrari for the price of a bicycle and demanding free gas for life. The kicker is, this guy isn't in court for shoplifting gum. He's charged with beating a cop so badly the officer needs surgery. That's not an oops, I made a mistake. That's a you just put your freedom in a blender and hit puree. And I'm right there with the judge, scratching my head, wondering how this man is even walking around free right now. Because let's be real, you don't wake up one morning, skip your Wheaties, and decide to assault 5 officers in a single day without some history behind you. No priors? I don't buy it for a second. It's the legal version of "this is my first time drinking," said by someone holding a margarita in each hand. And then, stacked on top of the police assaults, he's also facing domestic violence charges, 1 courtroom visit, multiple felonies, and a potential lifetime achievement award in bad decisions. This isn't just ruining a weekend, it's putting your entire future through a paper shredder.
So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe of Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not, it's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents. So,
Your Honor, I'm sorry, that is not the characterization of the R&O. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser. And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
Well, you had an opportunity to view the video.
Yes.
Let me ask you this. Was a taser deployed?
Your Honor, when
I think that's either yes or no. Was a taser deployed?
Your Honor, as soon as the officer saw him, she pointed the taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is not a situation where he was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Barroso, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding, I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. I don't. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about. I mean, I'm trying to figure out, because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon. There are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And
Yeah, so the defense here is collapsing faster than a cheap folding chair, and it's almost painful to watch. We've got 2 completely different contradicting stories, and honestly, their version sounds like it was written during a group project where nobody talked to each other. The judge throws them a softball, yes or no question, and instead of answering, they're dancing around it like it's a TikTok challenge. Meanwhile, this defendant is only 20 years old and still manages to rack up a highlight reel of police encounters, guns pointed, tasers fired, and he's still swinging. At that age, most people are worried about passing finals, not squaring up with law enforcement. The judge sees it, I see it, and you probably see it too. Something else is going on here, and it's not adding up cleanly. If I were the judge, anger management classes would be the first stop on this kid's new schedule, but classes alone don't cover the damage here. Time served feels like the only realistic option. You can't just fight off a fleet of cops and hope the system pats you on the back for effort. The way this case is going, the only suspense left is whether the sentence will be light or heavy.
in my view of the video, initially there was 1 officer, then there were 2, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there is there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
She is not, the domestic violence person is not injured. It was the shove and the taking of there's no injury to her.
The domestic violence are 2 misdemeanor counts.
That is
the felonies here are 5 counts of are 5 counts.
Yeah, I see that.
Are no causing injury.
Maybe I misread that on the report, but
Yes.
the injury to the fingers, that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructing that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured, that there are punches to the face of officers. I mean, Ms. Gaines, I don't get it.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
Tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture gonna up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
Thank you.
You can literally see the frustration building in the judge, head shaking, hand rubbing his forehead, the whole body language dictionary of I can't believe this nonsense. He looks like someone trying to solve a Rubik's Cube blindfolded, and the defense is not helping. They keep dragging the kid's father into the mix, which makes zero sense unless dad is secretly the governor. He's not getting anyone out of felony charges. I mean, what's next? Calling in grandma as a character witness because she says he was always polite at Sunday dinner? The whole angle is baffling, and even with all this chaos, the defense is still begging for a lower bond when $5,000 is already a bargain bin deal for charges this heavy. I've seen higher bonds slapped on people for shoplifting electronics, let alone stacking domestic violence with assaulting police. The judge ultimately keeps the bond right where it's at. No raise, no reduction, and honestly, that feels like the system's version of shrugging. Was it the right move? I'm not convinced, but I'm also not the one in the robe. At the end of the day, this defendant walks out with what I'd call a legal equivalent of a you got off easy coupon. And if he cashes it in wrong, he's not just burning a bridge, he's blowing up the entire interstate behind him.
All right.
We are here for PCC and bond violation. I understand the court has received and reviewed the materials that were sent over yesterday.
I did.
Thank you, Your Honor. The only request that we would have when we're discussing those materials, she is staying in a shelter in Livingston County. There is a separate DV having nothing to do with any of this, and there are some cross allegations in that case. So she's just requesting that we not say the name of the shelter if someone is listening on Zoom to where she's staying.
Understood.
Thank you, Your Honor. I believe that the materials that we provided were pretty thorough in terms of where Ms. Brown has been coming from and what her circumstances are in pertaining to the bond violation. So I was wondering if the court had any questions.
Well, I do, because while I'm not sure how you provided the materials, but I'm not sure how that relates to the specific allegations of the bond violation. Because what I have, certainly, maybe one might be able to look at the consumption of alcohol, but there was the tampering that occurred for a 12-hour period.
So I am going to let Ms. Brown address that herself with the court. You can explain to him where you're at in terms of the allegation of I had forwarded her the reports the same day. And just so that Your Honor knows, she did intend to turn herself into the jail this morning, but she was unable to get a ride this morning. And so she's here for in-person court this afternoon. So regarding the tamper on 6/23 and then the positive on 6/25, the court is looking for either an explanation or an admission as to these two.
Your Honor, I don't have any clue why those were coming up that way. I know that I was called in to community corrections to have my unit replaced for servicing. And when on my way there, Miss Julian called me and said that she received a notification from courts that I had a tampering and violation that she would, wanted clarification about. And I had no idea what she was talking about. I told her that I was just called in to do a replacement on the unit itself. I have only been at La Casa AA meetings and with AA people, because I don't currently have transportation and a license to get myself to and from these places. And I have not had access or been in the environments of drinking whatsoever. The only events outside of AA are AA events that I've been to, such as there was a sober rave in Royal Oak that I've gone to, but that wasn't even in the dates in question. So I'll stop with that. But I was completely confused. So I had the unit replaced. And while at community corrections, they had told me that I had this tampering and violation, 2 counts. And I was in for my reading the week before during this time, and they said that I was all set, good to go. We'll see you next week. And so I was really unsure why I was getting that unless it was due to needing servicing. But I'm saying, Your Honor, this is way too important.
Well, hold on a second. Just so that we're clear before you go on with your story.
Okay.
On June 23rd at the 12:56 a.m. time,
Yes, sir.
that's when the tamper is detected
Okay.
with the unit. On the 25th, there isn't a tamper, it's just drinking.
I don't know why it's coming up with that unless the servicing part of it needed it. Because at the shelter where I'm currently residing, there's a locked door policy from 11:30 p.m. until 7 in the morning. And I didn't have access any of those days to alcohol or have them in my possession at a no drinking facility. And I was at the facility at both of those times, documented on camera. I believe they have at the shelter, as well as my sign in and out sheet, and documentation from the shelter staff themselves saying that I was there and there was no evidence of me using. The doors lock at 11:30. I'm a smoker. I come in and I pretty much turn out the lights and go to bed by midnight every night. So honestly, I'm telling you, I do not know unless it has something to do with the servicing aspect of it. I don't have access to there, and it's a couple miles
Does she
away.
want a hearing on this? Because I'm going to tell you, I'm not believing what she's telling me.
Okay.
Then we would request a hearing and we would ask community corrections to bring a log of their, not just the violation reports, but if she's been indicating, and she did to me that day, that they called her to community corrections to switch out her unit. If there was a problem, and this would have been the unit that was switched out. After this, this would have been the problem unit, is what I'm saying, is that if there was a problem with the unit. So perhaps we hearing where community corrections can bring their documentation of what they did and when, and the servicing of their units.
How much time would the people need?
I'm emailing community corrections right now. And time that works for the courts, I can bring one of them over. Anytime that works for the courts, I can bring one of them over for a bond violation hearing, whatever the courts.
All right, I'll set it for August. I'll set the bond violation hearing as well as adjourn it this time the PCC out to August 1st, 2024. Actually, it's going to be at 3 p.m. because I got to be a hearing plus the PCC at that time. That's the bond in this case. Now, what I'm worried about is I issued a bench warrant without bond.
I understand, Your Honor. I informed Ms. Brown of that the same day that the court issued the warrant. I did instruct her to turn herself into the jail. I do believe that part toward the end of her letter that was directed to the court expresses that she was emotionally really grappling with coming into custody based on all of her circumstances that were outlined. I have continued to encourage her to turn herself into the jail. She was going to do so this morning, but she does not drive.
Ms. Julian, and I'll just tell you, that's part of my problem. Part of my problem is I know how you operate, Ms. Julian. You told your client, tell them what the right thing to do is, and they don't do it. And then today, or yesterday when we received the information and we understood she was going to turn herself in that morning. And so we were then trying to make sure that she was going to be on the docket at the proper time so we'd see her. So she was just sitting there and she doesn't turn herself in. And my staff, we're going all around trying to figure out where she is. And then I get an excuse she doesn't have a ride here. She's going to make her own call on all this stuff. And I appreciate the circumstance that she's in and have great sympathy regarding that, but I can't let you just go around violating what the court says you need to do.
Your Honor, I do have in the next week before the first medical alcohol treatment with another drug testing per bond order. And I also have general therapy with my counselor, my therapist, all of those appointments, as well as some medical appointments that are all before the 1st of August. I have not left the state, and I was here this morning. I was not able to get here to turn myself in, but I was here for this hearing, and I can assure you I'll be here on the 1st. I really need to make these appointments.
You shouldn't have had to go through whatever. And like I said, it's not like you didn't get the information from your attorney. You didn't get that. I'm reading everything she's sending me. She's doing a yeoman's job trying to represent you and do that. You're just not following through.
I do not have a license, and I'm really sorry that I was not able to turn myself in. I apologize for that. Thank you.
Did you call your attorney and say you couldn't make it?
No, I wasn't sure yet, but I.
See, and that's what I'm talking about. I mean, Miss Julian makes a representation to us that this is what you're going to do. This is everything. And then the person that's defending you and trying to make sure that the court understands everything about you, you're not even communicating with them to say this isn't going to happen. And then you're not following her instructions.
She said she'd meet me at 1:45, and I texted her at 1 o'clock and said I'd be here at 1:30 and that I would meet her at 1:45. I didn't ask her for a ride, though. You're right.
She did text me. It was after the morning, I want to say noon, that you were not able to turn yourself in this morning and that you would be here at 1:30. So I said that to meet me here since you were going to be meeting me here. So.
How'd you get here this time?
I had a friend of mine picked me up.
I think that what you want to do is you don't do what you don't want to do. And so you don't put the effort forth. And then everybody is sort of just misled as to what you're going to do. Well, it doesn't work that way. Because it puts a whole lot of people out. Because, like I said, we're going on Miss Julian's representation of what she instructed you to do and what you said you were going to do. And you didn't do it. And then everybody's looking around. We don't even know where you are or that you're going to show up at this time. You don't get to make those choices. So at this time, Miss Julian, you can file a motion regarding her additional appointments and other things that she may have to do. But at this time, defendant's bond is revoked, defendant's remand.
Mr. Your Honor, thank you. In the meantime, for the record, we are trying to see if we can resolve this case at district court level. So
Okay.
those conversations will continue. Thank you.
Thank you.
Wow, what a roller coaster that second case turned into. The defendant's mouth is writing one story, but the evidence is painting something entirely different, and the judge isn't buying a single syllable. Watching someone double down on lies while a bench warrant is literally hanging over their head is like watching someone juggle knives blindfolded. You know it's ending badly. And then we've got the ghost defendant, nowhere to be found, vanishing like she's Houdini when it's time to face consequences. That right there torpedoes her credibility faster than anything she could say. Because let's be real, if you can't even show up or let your attorney know, how is the court supposed to trust you'll honor anything else? Revoking bond wasn't just the smart move, it was the only move. And here's a legal nugget for you. Skipping court once might cost you bail, but skipping twice? Judges can legally deny you bail entirely, leaving you locked up until trial. Which makes you wonder, if someone keeps ghosting the system, should we even bother the second chances? Let me know your take down in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.